and the witness portion of the hearing should get underway shortly.
Press. Tom, just press right there. We took them from there.
Will resume. The committee went into executive session and reviewed the background investigations on Judge Roberts, which are routine, and Senator Leahy and I have been delegated to report that there are no disqualifying factors. We had Judge Roberts in for a very short discussion, and we returned to the hearing room to move ahead with our hearing. Senator Leahy?
I concur with that. The practice of this was begun with prior chairman. I think it's good to have it as a routine. We do this with Supreme Court nominees. We meet, go over the background. I agree with the chairman. There was nothing in the background of a disqualifying nature, and it was a pretty routine. And I mentioned this because I don't want anybody to read more into what is just, if anything, a housekeeping chore in this case.
Thank you very much, Senator Leahy. We have 6 panels of witnesses, total of 31 witnesses. It is our hope and expectation that we can conclude our work today. And while senators have rights to question, and we customarily have a 5-minute rule, to the extent that we can move ahead promptly, it would be appreciated. And we start first with the American Bar Association, and the chairman of the ABA Standing Committee on the Federal Judiciary is Mr. Steve Tober. Undergraduate in law degrees from Syracuse University, law review, deeply involved in the New Hampshire, New England legal communities, former chairman of the committee to redraft New Hampshire's rules of professional conduct. Thank you for joining us, Mr. Tober, and thank you for your service. And now we look forward to your testimony. All witnesses will be limited to 5 minutes, which is standard under our rules.
Thank you, sir. Mr. Chairman and members of the committee, my name is Stephen L. Tober of Portsmouth, New Hampshire, and it is indeed my privilege to chair the ABA Standing Committee on the Federal Judiciary. I am joined by Thomas Z. Hayward, Jr. of Chicago, sitting to my right, my immediate predecessor, and by Pamela Bresnahan, who was the 2004-2005 District of Columbia Circuit member, also of the 2004-2005 committee. For more than 50 years, the ABA Standing Committee has provided a unique and comprehensive examination of the professional qualifications of candidates for the federal bench. It is comprised of 15 distinguished lawyers who represent every judicial circuit in the United States and who individually volunteer hundreds of hours in public service to our profession. This committee conducts a thorough, nonpartisan, non-ideological peer review, and it does so by using long-established standards that measure the nominee's integrity, professional competence, and judicial temperament. In the sense that a major portion of the investigation consists of scores and scores of interviews with judges and lawyers, it is very much the voice of the bench and bar of this nation. Over the course of its history, the ABA Committee has never proposed a candidate of its own, nor do we do so now. Its function, rather, is to receive the name of each nominee, investigate and evaluate the professional qualifications of each nominee, and then vote. While factors used in considering lower federal court nominations obtain here as well, the committee's investigation of a nominee for the United States Supreme Court is further based on the premise that such an individual must possess exceptional professional qualifications. The significance, range, and complexity of issues that such a nominee will face on that court demands no less. As a result, our approach to a Supreme Court nomination has 2 procedural differences. First, all circuit members of the committee conduct confidential interviews within their circuits. And second, the committee works with at least 2 reading groups composed of a team of academicians and a team of practitioners who analyze the nominee's writings in detail and report their findings to the full committee. After the comprehensive investigation is completed and assembled, each member of the Standing Committee reviews the report thoroughly and individually evaluates the nominee using 3 rating categories: well qualified, qualified, and not qualified. Needless to say, to merit an evaluation of well qualified, the nominee must possess legal ability, experience, and reputation of the highest standing. With respect to Judge Roberts' nominations to the Supreme Court, the Standing Committee has rated him twice. When he was first nominated by the President to be Associate Justice on July 29th, the 2004-2005 committee, chaired by Tom Hayward, undertook a complete evaluation and measured the nominee's integrity, professional competence, and judicial temperament. That evaluation included interviews with more than 300 judges, lawyers, and community members throughout the nation, a review of his decisions and selected substantive memoranda from the National Archives by both our reading groups and individual circuit members, and an in-person detailed interview with Judge Roberts. Based upon that evaluation, the 2004-2005 committee found that Judge Roberts was unanimously well qualified to be Associate Justice of the Supreme Court. When the President thereafter nominated Judge Roberts to be Chief Justice on September 6th, the 2005-2006 committee, which took office in mid-August with 7 new members, performed a supplemental evaluation. That supplemental effort was focused solely upon the nominee's qualifications to perform the administrative and leadership skills incumbent upon the office of Chief Justice of the United States. This new committee had essentially a handful of days to perform that supplemental evaluation. Nonetheless, that supplemental effort included interviews with well over 80 judges, lawyers, and community members, a review of the materials gathered in the original report, and an in-person interview with Judge Roberts. Based upon that supplemental evaluation, and even with the change in membership, Judge Roberts was found by the 2005-2006 Standing Committee to be unanimously well qualified to perform the administrative and leadership responsibilities required of the Chief Justice of the United States. These two ratings, when considered together and in conjunction with the accompanying letter to your committee, which we asked to be made part of this record, provide the Senate Judiciary Committee with a comprehensive independent peer review. Allow me to summarize. The ABA Standing Committee is fully satisfied that Judge Roberts meets the highest standards required for service as Chief Justice of the United States. He has the admiration and respect of his colleagues on and off the bench, and he is, as we have found, the very definition of collegial. Mr. Chairman, the goal of the ABA Standing Committee has always been and remains, in concert with the goal of your committee, to assure a qualified and independent judiciary for the American people. Thank you for the opportunity to appear here. We're more than happy to entertain any questions.
Thank you, Mr. Tober, for your testimony. Thank you, Ms. Bresnahan, for your contribution, Mr. Hayward, for your contribution. We thank the ABA for your hard work and a very comprehensive report. Obviously, a great deal of effort has gone into it with the very extensive interviews which you have conducted. Senator Leahy?
They're probably going to feel left out and disappointed if we don't grill the 3 of them the way we grilled Judge Roberts for the last few days.
I don't think so.
But on their behalf, I'm willing to waive that.
We'll take that risk, Senator.
A vote has just begun. I think we can move ahead into the next panel unless any of the members have any questions which are important to be asked. Senator Wyden?
I just want to reiterate, we know how much work this entailed. I mean, it was an incredible amount of work, and truly, we thank you. There's been debates in this committee in the past about the relevance and importance of the ABA recommendation. I think it's important what you do. I think we all do now, and I want to thank you. It's a whole lot of work, and thank you, Steve, for your efforts.
Thank you,
Mr. Chairman. Senator Hatch?
Let me just second that. I've certainly appreciated over the years the good work you're doing, and I have to say that over the last number of years it's just been exemplary in every way. And I just want you all to know that, and we appreciate it. We know all the effort, and especially, Ms. Bresnahan, the effort that you've put in on a number of the judges that have come up in this area. You've worked your heart out, and I've got to say I want to compliment you.
Thank you, Senator Hatch.
Senator Sessions?
Mr. Chairman, I would also like to thank these members for their work, and would just point out that in the course of making these evaluations, you talk to the judges, lawyers on both sides against whom they litigated. You know from your own personal experience normally who will give a fair and honest evaluation, how to evaluate and place good judgment on a person's professional skill. So I do think that provides a lot of advantages for our committee, and I salute that. Secondly, let me ask if one of you would comment, just as a professional lawyer who've been involved in the practice for many years, how do you feel about the tendency that sometimes occurs to judge a lawyer by their client rather than how they perform honorably and effectively in court? Would you share your thoughts about that subject?
I guess what I would say, Senator, is that a lawyer is an advocate in the first instance and an officer of the court as well. And the roles are distinct, well-defined. And if we only defended those that didn't need our help, we wouldn't be doing very much for the American people. The role of a judge is very different. By definition, that person should know nothing about the case coming before them, should have no judgment about the parties in either way, and must be fair, fundamentally fair at the end of the day, so that litigants and lawyers feel they've been treated properly in our system. The only thing, Senator, that keeps our buildings of justice standing is the respect of the American people, and that's the product that comes out of that building from judges.
And you would have some concern that if a judge judged lawyers by their clients and didn't give them the full fair hearing in court, I guess you would say.
That's true, Senator, and I adopt the comments of Steve Tober. And I would even add to that, you should not judge it by who the lawyer represents, because the lawyer, as you've heard over the last several days, is there as an advocate.
Thank you, Senator Sessions. Thank you very much.
I didn't want in my saying there would be no questions to suggest that we don't have appreciation. I have been chairman of this committee, as have several others here. And we do know the work. We do know a number of instances where you've gone back and followed up on things. It is not easy. I should note for the people that are watching this, you don't get paid for doing this.
That's right.
You're,
That's
in fact, we couldn't have begun to afford it with the fees of some of you. If you did, you do this pro bono. It is a tremendous service to the Senate, but it's also a tremendous service to the bar overall, and I thank you for it.
Thank you, Senator.
Thank you, Senator.
It is a high compliment to have no questions or few questions.
Yes.
Could I ask one more?
We're diminishing the compliment now.
With regard to the lawyers and judges and others you interview, isn't it true that sometimes they're more willing to confide in you if they have a problem that they might share with someone else?
Go ahead.
I believe that's true, Senator. Tom served 6 years before being chair. I served 3 as a member. Pam's been on for 3. We all have had experience in talking to judges, to lawyers, to other community members who feel very comfortable understanding that what they tell us remains in the strictest of confidence. And we are able to do a true peer review because of that. I thank the Senator for the opportunity to explain that. We do get information of the most important kind from the process that we engage in.
Thank you very much, Mr. Tober, Mr. President Hand, Mr. Hayward. Thank you.
Thank you, Senator.
Chairman.
I think that makes us nominate that report particularly valuable, Mr. Chairman.
I agree with you, Senator Sessions. We'll now call our second panel, Governor Thornburgh, Congressman Lewis, Commissioner Braceras, Mr. Wade Henderson, Commissioner Karasnow, and Judge Jones. While the panel is being seated, just a word of explanation. There is a vote in process, but there is a second vote behind that, so that when we break to vote, it is most efficient to vote a second time before returning. But we never know exactly when the first vote is going to end, so that our time is best economized if we arrive there about 20 minutes after the vote has started, so that we can return as promptly as possible. Our first witness is the distinguished former governor of Pennsylvania, Governor Dick Thornburgh, elected in 1978 and reelected in 1982, Attorney General for both President Reagan and President George H.W. Bush, Undersecretary General for Administration and Management of the United Nations, currently counsel to the international law firm of Kirkpatrick Lockhart, and a longstanding friend of mine. Began in 1966 when I campaigned with him in Squirrel Hill when he ran for the Congress of the United States. Governor Thornburgh,
always appreciate that.
Thank you for joining us.
Thank you, Chairman Specter, other distinguished members of the Judiciary Committee. It is my distinct honor and privilege to be here today in full support of Judge John G. Roberts' nomination to be the 17th Chief Justice of the United States. I've known Judge Roberts as a friend and colleague for over 15 years and can attest to his outstanding personal characteristics and undoubted integrity. Perhaps more important for present purposes, Judge Roberts' extraordinary legal skills and keen intellect are undisputed. Before his Senate confirmation by unanimous consent over 2 years ago to be a judge on the D.C. Circuit Court of Appeals, he was heralded by leading Democrats and Republicans alike as one of the very best and most highly respected appellate lawyers in the nation, with a deserved reputation as a brilliant writer and oral advocate. He is also a wonderful professional colleague, both because of his enormous skills and because of his unquestioned integrity and fair-mindedness, that from his peers at the D.C. Bar. I can echo this fanfare because of the deep and lasting respect I have for Judge Roberts' legal abilities that I saw firsthand when he served as the principal Deputy Solicitor General while I was Attorney General under Presidents Reagan and George H.W. Bush. In that capacity, Judge Roberts represented the United States government in all manner of cases before the Supreme Court, where he was charged to defend, among other things, legal attacks on the constitutionality of acts of Congress. John represented the government in 39 cases before the Supreme Court while in the Solicitor General's office. He is a truly remarkable lawyer, bright, witty, capable, respectful, and creative. I had the good sense to enlist him as my coach for my final appearance before the Supreme Court myself in 1991, and we won the case. On the Court of Appeals for the last 2 years, Judge Roberts has demonstrated in practice the principles he has articulated as a young attorney working at the Department of Justice. Reflecting on the role of judicial restraint as a guiding standard for how courts should approach the judicial decision-making process, Judge Roberts explained in materials he drafted then for then Attorney General William French Smith, and I quote, "The phrase judicial restraint may mean many things to many people, but at its core, it is a notion that federal courts must scrupulously avoid engaging in policymaking which is committed under our system of government to the popularly elected and accountable branches of the states. Judicial activism," Judge Roberts stated, "is neither conservative nor liberal." He recognized that throughout history and to this day, both liberal and conservative interests have sought to enlist an activist judiciary in the achievement of goals which were not obtainable through normal political processes. Today, different groups urge judges to substitute their own policy choices for those of federal and state legislatures, but the evils of judicial activism remain the same, regardless of the political ends the activism seeks to serve. So said Judge Roberts. Indeed, he sagely recognized that the greatest threat to judicial independence occurs when the courts flout the basis of their independence by exceeding their constitutionally limited role and engage in policymaking. Let me highlight just one of Judge Roberts' D.C. Circuit opinions, which clearly reflects the correctness of his approach that cases should be decided upon the text of the statute, the Constitution, and the particular facts before the court. I know that most members of this committee are familiar with this case, which has been nicknamed the French fry case. The facts are straightforward. The D.C. City Code made it illegal to eat or drink in a metro station, and the local transit authority imposed a zero-tolerance policy for violations, since it had received complaints about bad behavior in certain metro stations. A 12-year-old girl who stopped at a fast food restaurant on the way home from school made the mistake of eating a French fry while waiting for her friend to purchase a fare card. She was arrested and hauled off to jail for booking, and ultimately, some 3 hours later, delivered to the custody of her parents. Was this bad policy? Yes. In fact, after the publicity surrounding the case, the City Council adopted a new rule whereby they would merely issue citations to juvenile offenders rather than arresting them. Was the policy unconstitutional? Both the district court judge and the unanimous panel of the D.C. Circuit agreed that it was not, because age, or more specifically youth, is not a suspect classification under the Constitution or any act of Congress, and because probable cause existed to support the arrest, since she did in fact eat the French fry in violation of the city's zero-tolerance policy. Why discuss such a seemingly silly case? I think that in the opening paragraph of the decision, which I will quote, Judge Roberts forcefully establishes his understanding of the court's limited role, while at the same time expressing hope that the policy is changed at the appropriate level. He said, "No one is very happy about the events that led to this litigation. A 12-year-old girl was arrested, searched, and handcuffed. Her shoelaces were removed, and she was transported in a windowless rear compartment of a police vehicle to a juvenile processing center where she was booked, fingerprinted, and detained until released to her mother some 3 hours later, all for eating a single French fry in a metro rail station. The child was frightened, embarrassed, and crying throughout her ordeal. The district court described the policies that led to her arrest as foolish. And indeed, the policies were changed after those responsible endured the sort of publicity reserved for adults who make young girls cry. The question before us, however, is not whether these policies were a bad idea, but whether they violated the Fourth and Fifth Amendments to the Constitution. Like the district court, we conclude that they did not. Judge Roberts has also stated repeatedly his belief that cases should be decided on the merits, not on the basis of a judge's personal opinion. As he expressed as recently as this past July in United States versus Jackson, sentiments do not decide cases, facts and the law do. Understanding that most basic principle highlights the significant difference that exists between a lawyer acting as an advocate on behalf of a client and the role of a judge, charged with deciding cases fairly and objectively. But all too often in the sound bites that have passed for reviews of Judge Roberts' record, one group or another will state that Judge Roberts doesn't support, for example, the rights of criminal defendants, environmental enactments, or the civil rights laws, or most egregiously, that Judge Roberts condoned the bombing of women's clinics. The supposed basis for these claims is gleaned, interpreted, and misconstrued by these critics from their interpretation of arguments that Judge Roberts made as a lawyer, both in private practice and for the government. The distinguished members of this committee can easily see through this argument, for we all know and appreciate that lawyers are duty-bound to be zealous advocates for their clients. Cases argued by Judge Roberts as a government lawyer or a lawyer in private practice, in my opinion, say little about how John Roberts, as a Supreme Court justice, will approach cases other than as he has all his professional life. He approaches matters with great skill, dedication, and earnestness. It is John Roberts' record as a jurist that is most impressive and most persuasive. It is a record that speaks of a judge who understands the role of the judiciary, who approaches each case independently and objectively, who respects history and precedent, who interprets the law based upon the facts before him, who does not engage in judicial policy making, and who will make this country proud as the next Chief Justice of the United States. I sincerely appreciate the committee's invitation to speak today and the committee's careful and deliberate consideration of Judge Roberts' nomination. He is, in my view, an exemplar of what we should seek in our next Chief Justice. Thank you.
Thank you very much, Governor Thornburgh. Congressman Lewis is voting at the moment. Do we know how much time is left on the vote?
5 minutes.
Time has expired? Well, the time has expired, so we're going to go vote, and we'll return just as soon as we can. The committee stands in brief recess.
On your screen, that's Wade Henderson. He's with the Leadership Conference on Civil Rights. He'll be on one of the upcoming witness panels here in the confirmation hearing for John Roberts to be Chief Justice of the United States. The committee's taking a break so that senators can return to the Senate floor, voting on a couple of amendments to 2006 spending for Departments of Commerce and Justice. So we'll stay here in the room while that vote is underway. Just to let you know, they will be taking a lunch break this afternoon. They expect to be back at about 2 o'clock Eastern with more panels. There are a total of 6 panels of witnesses, and the committee also expects to wrap up early this evening, 6 o'clock Eastern or so. And a reminder that you can watch all of today's hearing in its entirety tonight, C-SPAN 2, 9 o'clock Eastern. The right of your screen is Representative John Lewis of Georgia. He's on one of the panels coming up, one of the 6 witness panels that will appear before the Senate Judiciary Committee this afternoon. The Senate's in a break, or the committee's in a break. They're on the Senate floor voting on a couple of amendments to the spending for 2006 for Commerce and Justice, and they'll resume with the witness panels when the votes wrap up.